For inclusion. Copy, sir.
My lord, one
List
matter.
of notice.
My lord, may I be permitted to mention one matter? I mentioned this matter on 27/8/2025 for preponement of hearing. I also submitted, but it is not. It has not come on.
This will come on the returnable date.
My lord, it can be disposed of, my lord. It's a one.
What is the next date? This month it's not possible. You
Sir,
come after
it's on
vacation.
November, my lord. 10 November.
Yes,
My lord, can it be? It will
it can't be.
oblige.
Lordship, one very old matter, Lordship, service matter, dismissed on the ground non-appearance. It's an application for restoration.
You filed, you serve notice and then come.
Application for restoration, this is for this is notice storage. Permitted to mention one matter, item 61 of Justice
When the which court?
Justice Parthasarathi Chatterjee, court number 7, expeditious disposal.
আমাদের determination আছে? You mentioned before the appropriate bench. Next.
Bank for the state responding lordship, two different occasion matter was called for, and in spite I was appeared, but in spite of that, my name not been recorded, lordship. And lastly, lordship, 10th June matter was.
It was dismissed for default.
Yes, but I am for the respondent. I was present.
You were for the
State respondent. I was present when the matter was called, but my name not been recorded, lordship. Kindly appreciate.
If you were present, then why will your name not appear, sir?
Lordship, I give the slip. In spite of that, my name not been recorded.
কখন বন্ধুত্ব কখন শত্রুতা? Next. And for this you mentioned.
If my
Next.
name not been recorded, then I cannot appear, lordship.
My lord, ready for hearing, my lord. I'm for the respondent. My lord, very short matter. Any day for us.
Paper book is there?
Yes, yes. Already filed.
The learned advocates representing both the parties are present. Next date be fixed on 21st of November. For orders. Next.
Collection of a stay application. Stay, we have deposited 25,000 while filing the application. While filing the appeal, I pray for a stay measure. We will deposit the entire amount in meantime.
The report of the stamp reporter mentioned the appeal to have been filed within time and in proper form. Let the same be admitted. Have you deposited the copy of the challan?
Yes, sir.
1 week after vacation, within that period, you deposit the money, the remaining amount of compensation, and serve notice and file affidavit of service. Next date, 17th of November. Next.
Can I start one copy of paper book, madam?
My lord, can you give me leave to file the informal paper book, madam, for early hearing?
Paper bull filed by the learned advocate representing the respondent claimants be kept on record. Your stay was made absolute earlier.
Yes, madam.
Yes,
You are appearing for the insurance company.
What the application?
I am for the respondent.
Next date be fixed on 18th of November. Next.
We have already withdrawn 8 lakh rupees, madam.
My appeal, Your Lordship, the stay needs to be made absolute and my affidavit of service. All the parties have been served. There's an advocate who has been served in this matter.
The report of
They
the
need to
staff
be made absolute.
reporter.
They already been given. I have filed the pool and panel payment. Stay needs to be made absolute.
State absolute.
And affidavit of service is there.
Affidavit of service be kept on record. Despite service of notice, none appear to represent the respondent claimants. Register administrationary auditor. Next date, 21st of November.
Keep the question, Worship.
Next.
Well, today was the date fixed for my London Fest argument.
No, today was not fixed as last chance. Yes. Yes, what is it?
Departmental proceeding, Lord, and some
Punishment.
punishment was awarded. That's right.
Removal from service.
No.
No, no.
Stoppage of increment with
Stoppage of
cumulative effect.
Stoppage of increment.
With cumulative effect.
Appeal was made. Initial de novo proceeding was there. It did not file an revision application. That was rejected.
Written notes filed on behalf of the learned advocate representing the Respondent Union of India be kept on record. Hearing concluded, CV. Next.
Proceedings.
$14.50.
Petitioner one.
I'm for the state respondents in this matter, my lord.
Yes,
Well, in spite of your lordship's specific direction, my lord,
they did not file any exception.
they did not file. Have a copy of the writ petition, my lord, till date, my lord.
My lord,
In item number 14, my lord.
Who are you? Are you the advocate on record? Then let it be dismissed, sir. None appear to represent the petitioner. The learned advocate representing the state is present. Let the matter be dismissed for non-prosecution. Next. 14:15.
দাদা আগের ব্যাটারটা আগেরটা 6-এরটা
Sixteen, my lord, I'm praying for some time to file the affidavit reply, my lord.
On the prayer of learned advocate representing the petitioner to file the affidavit in reply, next date be fixed on 22nd of September as last chance. Next. Yes, sir.
Your Lordship heard my matter on the last occasion. This in respect of Provident Fund, which was not paid to us equally under the law. And your Lordship was pleased to indicate the guidelines under which the particulars I have to produce the your Lordship. That I prepared. Before this, I will hand over to your Lordship because your Lordship wanted to know these are the criteria your Lordship criteria and requirements indicated by your Lordship to be fulfilled by me by indicated. The petitioner currently presenting the case. I have prepared.
Sir, for how many petitioners are you appearing?
I have got the note. I prepared the note for the Lordship.
Sir, for how many petitioners are you
I have
appearing?
indicated. Now,
Out of 31, 18.
now I'm giving you Lordship. the indication can this.
নোট আমাকে দেবেন
Before this note, একটা copy আমার একটা copy দাও। What
বাবা।
I've indicated.
বড়
And
নামটা দিয়ে দিলে
You are representing 4, 6, 8, 9, 10, 11, 14, 15, 16,
small.
19, 21, 22, 23, 25, 26, 29, 30, and 31. These are the ones whom you are representing. The others are not represented.
One of the question more today, my first submission before your lordship. It will take only half an hour before your lordship because your lordship is a very brilliant judge. Only 20 minutes will be taken to satisfy your lordship. One.
I have got this now.
Please.
আমি স্যার একটা
Please.
আচ্ছা ঠিক আছে আপনি
Please.
Sir,
Only-
today I got stuck in the traffic for 40 minutes.
Yes, yeah.
Every 5 minutes. Calling.
One submission.
flyover.
One submission.
No.
One
Ma
submission.
flyover was late. So you must be knowing the condition, the manner the buses were kept. And so I mean, it was so difficult for the vehicle to move
We come out at
from
quarter to 9.
from
Come out
Gariahat
at
till
quarter
that place. So
Quarter to
in
one
any
submission.
today I can't give you half an hour, sir.
You lordship can give me half an hour or 20 minutes time. যাও না পরে আমি জজ সাহেবকে বলি 10 minutes time can you lordship give me
Today?
today?
Yes, only 10 minutes, sir.
10 minutes. My lord, this is in respect of Provident fund available to the employees. Share, equal share I will pay. Equal share will be paid by employer. Out of that, one portion will go to the Provident fund and another portion will go to the pension. Under the act, unless I, at that earlier point of time, unless I had the pay salary of 3,500 per month, I could not be a member of the Provident fund. Subsequently, it was raised by the government of India in the Provident Fund Act that I should draw the salary 6,500 per month. Then I can be a member of the Provident Fund. Subsequently, amendment was made in 2014. If I draw salary more than 15,000, I can be a member of the Provident Fund. My employer used to direct me to pay 12% of 6,500 basic pay without allowances. Law says pay includes allowances, house rent allowance, and DA, everything. They exclude the allowances, giving a limited meaning to the word pay, though law says it includes everything. That illegality was committed at the embryo by the employer, for which we have to contribute less amount. They have to contribute, employer has to contribute less amount. For that, we have been compelled to receive less amount of Provident Fund vis-a-vis pension, namely 2,000 to 3,000 rupees per month. In 2014, when my salary exceeds 42,000, they made the ceiling at 15,000. And out of that, 12% I will have to pay, 12% they will pay. Now, my submission before Your Lordship kindly remember this submission, that this disparity was created by the employer to cause suffering upon us in violation of Provident Fund Act and the rules and scheme. And they say you belong to the excluded employee. Excluded employee means a person who is drawing salary 6,500, then I will be entitled to Provident Fund. When my salary was enhanced under the third pay commission, fourth pay commission, fifth pay commission, sixth pay commission, they did not give any effect to this. Salary I was getting 50,000 per month, but they have fixed the ceiling at 15,000. So only with a view to particular tricks that I can get less amount of pension and provident fund on the day of retirement. This is the crux point for Your Lordship to be decided.
So you go through this.
I'm going through this. I'm taking instructions for Your Lordship. Fix the matter after baggage.
And the officer concerned should be sent to jail. They have caused
The second thing, I'm
inhuman torture on us. We are beggars now. 2,000 rupees and 3,000 rupees pension now. We are beggars. These officers, they are getting money. No, I am making submission before the court. Don't disturb me. Make the submission later, my lord. My lord will hear you. Kindly consider this aspect of the matter. Kindly
Okay,
give a
sir.
short date,
one thing.
and you also kindly take it up a part of matters.
No, sir.
One thing is this.
My lord, kindly make it a part of matter. After making, as and when you lordship.
I am
after one week or
extremely
at any point of time.
intimidated by you people, sir.
That should be sent to the CBI because they have created amassed wealth, depriving us. This particular
One thing,
person.
may I submit here? Respond number 1 and 2 and 7 is the authority of the state government who are dealing with the matter. I don't know whether they have appeared or not. Without their appearance, the matter cannot.
Have you made them the party?
They have made
Make
their
the party, they have been served also.
But if they don't have, we are one of the
Who are the respondents,
Stop
sir? Wait, you are respondent number?
3 to 5.
The learned advocate representing the respondent number 3 to 5 submitted that the presence of the respondent,
Let him solve. It
Not
is
just
an,
some
they are their
respondent
employer.
number.
Respondents number.
He is their employer. Government is their employer. Let them serve.
So now, sir, you let him speak.
Respondent 1, 2, 1, 2, and 6.
1, 2, 6,
7.
6, 7 are required for proper
No, 6, no, 6, no, only 1, 2, and 7.
1, 2, and 7, 6 are required for the adjudication of the instant writ petition. The learned register administration LOM is to serve notice upon the respondent number 1, 2, and 7 for proper representation before the court on the next date of hearing. Next date we fixed on 19th of November.
Part my lord. Part my lord. Kindly deal. My lord, I got the point, my lord. Your lordship got the point. Because your lordship, I know, so far at this age, I can find your lordship is one of the brilliant judges of this honorable.
No, sir, no, sir.
Kindly part heart, my lord. Kindly part heart. Let us try our luck.
Any other day.
Let us try our luck.
Which one?
19th of November, except any prior or after.
21st,
21st March.
21st November.
2,000 rupees, 3,000 rupees pension. They are street beggars. We cannot tolerate as a human being. You also know that.
I told you, sir, I'm extremely afraid of all of you. Then you will write letters.
I'm grateful to you, Lordship.
Professor Lordship required me to produce the original one. Just today, I got it.
You have received it?
I have received today, they came here.
So where is the
My copy is not here.
Sir, is this your matter?
Yes, yes, yes. 22 আপনি আছেন তো? 22 অমিত কুমার। আপনি আছেন এটা SSB matter. My learned friend may require my lord some copies from the original record. In that case, my lord,
What happened, sir? How come you forgot? No. It's not in this matter.
পেয়েছি আজকে কিন্তু আমার নিজের কাছে কপি নেই আমি আজকে একটা ফটোকপি করে আপনাকে দিয়ে দেবো
You are
This is the copy. Your lordship kindly allow me to retain it for 1 day. Thereafter, I will give it hand over.
the learned advocate representing the Respondent Union of India submitted to have received a copy of the original case records pertaining to the disciplinary proceedings instituted against the petitioner and seeks a day's accommodation to prepare Xerox copies of the case of the case records for his personal use and file the original case records tomorrow.
Tomorrow. Yes.
Tomorrow.
It should be better.
Next date be adjourned for the next let the matter be.
Let it be kept under same custody because since the original.
No, you give it tomorrow, then we'll see. Let the matter be adjourned for the day. No presence and not presence.
Hello.
Yes, sir.
All documents they asked for submitted except the death certificate because it was died in 2014. So I applied for death certificate about verification. AMC issued death certificate duplicate and that has been submitted yesterday before the LIC.
Yesterday, Malad, kindly
What
keep
can I
it.
do? Malad, you know the Calcutta Corporation applied long back.
Sir, at least you have received it.
Received it yesterday. Kindly keep it, Malad.
Okay, the learned advocate representing the
My officer
petitioner
has already gone.
submitted to have forwarded the copy of the death certificate to the office
Along
of
with
the,
other documents.
along with other death certificate, along with other documents at the office of the respondent LIC.
On yesterday.
Most of
LIC
them earlier.
yesterday. Next date be fixed on 25th of November for compliance by the respondent LIC.
It will be released.
Then you come and mention.
Yes.
Next.
I appear for the petitioners. The petitioner. On the last occasion, I have filed my exception to their report.
Who are they, sir?
They are Gujarat Tourist Corporation, Gujarat Corporation,
So,
Tourism Corporation of Gujarat.
who is
They were required to file the payslip how the petitioner was paid, whether directly by the employer or by the contractor. That was the moot question, my lord. They did not supply those papers, my lord, which were required by your lordships and also predecessor in office of your lordship. That is Justice Datta's order, as his lordship then was.
Sir, I'll fix it for last chance. Okay, sir. If they do not appear, then you can continue. Earlier also, this was their conduct. The learned advocate representing the petitioner is present. None appear to represent the respondent. Tourism Corporation. Next date we fixed on 19th of November as last chance. Next.
Well, I am for the state respondents, my lord.
I am for the respondent number 3.
Yes.
Matter is essentially in respect of the my lord, the scale benefit which pertain to the increment that the petitioner was entitled to, as well as the subsequent reduction in the pension which the petitioner is now receiving, apropos the reduction in the scale benefit which he was entitled to for a period of 5 years. In a nutshell, my lord.
So if you remember, on the last occasion, I had asked you certain questions.
One of the questions were that on what basis I have the petitioner basically come to a finding that he is entitled to get the scale benefit. Now, my lord, if your lordship sees, we have annexed a minute which is the 28 minute. Now that 28 minute
The
essentially
dates were different
sorry, my lord.
in those documents.
No, my lord,
You referred to one resolution.
No, my lord, that's a minute.
That board resolution.
That's a minute. That's a minute, my lord. The minute is subsequently there. If your lordship kindly takes it up, it's part of my affidavit in. It's part of the rejoinder affidavit, my lord. Your lordship kindly comes to page 22, my lord, of my affidavit in reply to the opposition which was submitted by my learned friends here. Affidavit in reply, কোর্টে ফাইল করা হয়েছে। হ্যাঁ হ্যাঁ রাজশ্রী স্যার। 4th August 2025. হ্যাঁ হ্যাঁ, yes, that's it.
Yes.
Lordship kindly takes page 22, my lord. Minutes of the 28th meeting of the West Bengal Comprehensive Area Development Corporation held in Writers Building office of the Chief Minister on 22nd June 1983. Lordship will kindly come to page 29, which is a continuation of the minutes of 22nd June 1983. List of employees appointed during the period subsequent to the list furnished in the 27 meeting. Now, there was a list, my lord, published in the 27 meeting. From 27 to 28 meeting, in the interim, people who have been appointed, their names are essentially mentioned here, my lord. The petitioner, my lord, would kindly take page 30, is in the role as 70.
Mention that the issue of the petitioners were discussed in that earlier meeting, and I had asked you to indicate the paragraph wherein their issue was discussed.
I was wrong, my lord, in explaining the issue before my lords. The petitioner here, my lord, was originally appointed as a junior technical officer organization. Now that is the position which is coined while fresh appointments are being given. Petitioner was appointed in 1980, my lord. Subsequent to that, in 1982, there was again a fresh process being initiated for technical officer organization. Now, both these posts are separate posts. It's not that he got promoted from junior technical officer to technical officer. There was a separate interview process which was being conducted, and his salary bracket was fixed from the his pay bracket was fixed in the range of 660 to 1200. Now, for any salary bracket which was in excess of 500, that needed to be approved by a board which would be chaired by the chief minister. Their contention, my lord, is that I got appointed in the 38 meeting.
37.
Sorry, 37 meeting. My contention is I got appointed in the 28th meeting. And I have also produced the minutes to that effect. That minutes, my lord, is annexed in my rejoinder. I had also filed an application, my lord, which was served upon my learned friend. Now they have taken an exception to that application, but nowhere have they denied the existence of these 27 minutes. In the writ petition which was filed
Your
by
name appears in the in that list.
Yes,
at
madam.
page 29.
At page 29, Rule 77. SI number 77.
But then the list was furnished in the 27th meeting.
My lord, in the 28th meeting, because the 20.
No, you come to page 29. List of
Subsequent to
employee.
the list furnished in the 27 meeting. This is a subsequent list, my lord. So the 27 meeting was
So
held.
if it was only related to the 28th meeting, then why 28th meeting has not been mentioned? What do you mean by subsequent to
My
the
lord,
list furnished?
I'll just explain your lordship what the procedure is. My lord, a meeting is held today. In the meeting, people who are appointed earlier or who have been given an appointment letters earlier, they are confirmed in that particular minutes. Because the appointment is given by the corporation. The confirmation of that appointment has to be made by the board. So the confirmation comes in that board meeting. So the confirmation is always prospective with retrospective effect. It is not that the confirmation comes and then the employment starts. The confirmation is prospective, but with retrospective effect. So it starts from the date when the appointment letter is issued to the petition. So in the instant case, the minutes essentially takes into consideration subsequent appointments after the 27 board meeting which was held. So that's why it says subsequent. So after the 27 board meeting, till the 28th board meeting which happened on 22nd June
You mean to say
1983.
in the 27th board meeting, their issue was decided. And
No,
subsequently,
I
the
mean to
list
say
was
in the 28th board meeting, the issue was decided.
28.
Yes.
Then why is 27th
My
meeting?
lord, that says subsequent to 27 board meeting. That doesn't say a
That's
subsequent.
exactly what I'm asking you.
So that's what I was, my lord.
Please try to understand. Subsequent to the list furnished in the 27th meeting. So this list was furnished in the 27th meeting
No, my
for
lord.
what purpose?
This was furnished in the 28th meeting, subsequent to 27 meeting. Means the 27 minutes were concluded after that. Till the 28th meeting that took place on 22nd June, this is
So
the
their
list.
matter must have been discussed in the 27th meeting so that the list
My lord,
was
their
prepared.
matter could not have been discussed in the 27 meeting because the 27 meeting was held earlier. This meeting, which was held on 22nd of June 1983. The petitioner was being given appointment in February 1982. So his
So their matter must have been
must be
discussed.
subsequent.
Their issue must have been discussed in that 28th meeting also.
Yes, my lord. So that's what I am relying on. The minutes of the 28th meeting in which they were given the confirmation.
Show me that portion.
Yeah, that's what I was just showing you. And that's what I was relying on, my lord, at page 30. The list starts at 29 and the minutes start at page 22.
20?
22. is the page in which the minutes start. If your lordship kindly takes page 22, at the top of the page, my lord, it says minutes of the 28th meeting of the West Bengal Comprehensive Area Development Corporation
Yes,
held in Writers Building, Office of the Chief Minister on 22nd June 1980.
right now indicate the paragraph. Because there must have been several issues taken together.
Yes, my lord. So I don't intend to trouble your lordships with the paragraphs which are mentioned here. I would just urge your lordships to come to page 29.
In 28th meeting, I don't find any reference
My lord,
regarding their
this is in
confirmation.
continuation of the 28th board meeting, because if your lordship comes to page 29, at the top it says 28 corporation meeting minutes. Page 29, at the top left-hand side. If your lordship kindly says 28 corporation meetings.
So then why are you indicating this 22nd page number?
Well, 22nd is the start of this minutes. And what I'm indicating is the list of employees who were appointed in this meeting.
Sir, where is that resolution? A minute? Where is that minute that they were appointed?
That is what it says, my lord, with deepest respect. At the
That is
start
not,
of
it's
29,
not there.
my lord, if your lordship kindly sees this, my lord, schedule 1. And it says,
Where is it?
my lord, at the top of it, if I can take the liberty of, my lord, just
Which
showing
page? Tell me which
page 29, my lord,
Schedule 1, right?
schedule 1.
Now, where is that schedule 1 for consideration of schedule 1?
My lord, that is subsequent. Schedule 1, it says list of employees appointed during the period subsequent to the list furnished in the 27 meeting. So a list like this has been furnished in the 27 meeting.
Where is the minutes of the 27
No, the
meeting?
27 meeting, I don't have a copy that they can produce, but in the 28 minutes, the list is furnished of the corporation in the salary range of above rupees 500 per month, because that is the norm. Salary of excess of 500 needs a confirmation from the board. Now the list, name of employee, designation, SI number. And my SI number, your lordship, is 77 at page 30. Technical officer, organization.
No, was it the case that the petitioner was appointed and thereafter transferred?
No, my lord, there is no transfer which has happened. And it's not the case of the petitioner.
Then why have you annexed this document at page 32? Transferred from such and such to such and such as per schedule 2. List of employees transferred during the period subsequent to the list furnished in 20.
That is a list of separate employees. I have annexed the full minutes. In that list, my name doesn't fall. In that list, my name doesn't fall. My name is only for the appointment during the period.
No, what is your prayer?
My lord, my prayer is, now since I have been able to demonstrate that I was appointed in the 28 minutes, so my prayer, my lord, is I need to be given the scale benefit for the period 83 to 88, because there is a career advancement scheme apropos which in 2004, 1/6/2004, my lord, there is a notification issued by the department that basically recognizes the service which I have done, but entails me scale benefit from 88. They say that prior to 88, that is from 83 to 88.
You mean to say no formal appointment letter was issued in your favor?
Oh, my lord, appointment letter, everything is there. Their contention is I was an ad hoc employee and not a permanent employee for
From
those 5
83
years.
to 88.
Yes.
So you show the document where you were appointed on a permanent basis and not.
This is the document, because this document.
The document doesn't state as to how you were appointed. It mentions only a list, neither does the minutes itself specify.
My lord, would kindly take my appointment letter, my lord.
Where is it? Which page?
Please allow me to place it. If your lordship kindly comes to annexure P1, my lord.
P1.
Yes, my lord. That is at
P1 is which?
page 15, my lord, of the writ
The-
petition. Of the writ petition.
Writ petition.
West Bengal Comprehensive Area Development Corporation. This is, my lord.
15. Is it page 15?
Yes, my lord, page 15.
Page
1-5.
15.
Yes.
My lord, on the right hand side, below compre Dave, it's written dated 24th January 1980.
7th of February 1980.
Oh, my lord.
On the right side, do you see? Page 15, P1 collectively, is that they dated 7/2/1980?
10/24/180. Sorry, my lord.
কার ফোন বাজছে?
Things are jumbled up. What your lordship is referring to, 7-80 is the second page. The first page, my lord, is 24/180.
There should be
The
page
earlier page is the affidavit.
affidavit page 14.
My
And
lord, can
15?
I just have my lord's?
Page 15 আমার
আমার কাছেও page 15.
Sanchal?
15 হবে।
My lord, if it's not inconvenient to your lordships, my lord, I have page 15, which is just preceding the instant page. No, no.
Page preceding page 15, that is page 14 is the affidavit.
ওটা মিসিং হয়েছে ওগুলো নেই original।
My lord, it's immaterial, my lord, but it doesn't turn my case in any fashion. 7/2/1980 is actually the one. What I was referring to, the document is essentially,
Sir, this document is not there on record.
my lord, that I find is not there because it's a change brief, my lord. I didn't file when the writ petition was filed. But this document is there with all my learned friends. I find that it's not there with the court.
Page 15 is
But be
first page. আমি তো
But
এক
be that
মিনিট
as
অনেক মিনিটই তো নিলাম একটা
be that as it may, my lord, I don't intend to, the case doesn't turn on this particular page.
So this is the call letter.
Yes, my lord. After that, that is the letter which your lordship was referring to. So the case doesn't turn on that particular document.
What is
So
this
on
say?
7/12/1980,
Well, we are
the
going
petitioner was appointed as a junior technical officer.
basis.
Yes,
For
ma'am.
2 years with effect from the date of your joining as junior technical officer
Yes,
under this corporation in the base of such and such.
yes, my lord. So 1980, I am being appointed.
To minute, you're directed to. So then after 2 years, were you confirmed?
My lord would kindly now come to,
my lord, please see page 16.
my learned friend will get an opportunity.
Given upon materials, I am
My lord will get, my learned friend will get an
I'm
opportunity. I am not
I am
going to
supporting
disturb
you.
my learned friend.
Sir, will you please wait? Yes, 2 years temporary.
Yes, my lord. Then my lord would kindly come to page 17, which is 24/11/1982, where I am again being told to appear for a technical officer monitoring. This is a call. And then at page 17, which would be your,
The documents you have not annexed with the writ petition.
my lord, I am reading
Page
from the writ
17,
petition.
It's not there on record that you had called for you were called for the interview.
My lord, in my copy is there, my lord. I am very sorry, my lord, that's not there in your lordship's record, but in my copy I have it, my lord. Read petition, my lord. This is read petition.
Let me see once. Earlier copy though.
That's not there, my lord. That unfortunately, my lord, I was not the advocate on record who had filed it.
No, after two. No, here also it's not there. Your call letter for the interview is not there. Anyway, page 17 relates to
The
you are hereby appointed to the post of technical officer.
yes, my lord.
That portion is there.
13/12/82, I am being appointed. Here also, my lord, it says existing rules which are followed on a temporary basis for the period up to 30th June 1984 with effect from your date of joining. Now, your lordship will have to read this in conjoint with the minutes which I have now annexed in my rejoinder, which is at page 22, and my name is appearing at page 29.
Page 22
is where the minutes start, my lord. And my name appears, my lord, at
name
page
appears, I can understand. Why
30.
but why is the name appearing?
Because, my lord, I was appointed. I was appointed in that board meeting.
What is the reason? Sir, you come to page 22, proceeding, right? The minutes of 27th minutes meeting
Yes.
of corporation were confirmed. Annexure A.
Yes.
So what is the issues that they were confirmed? Get hold of that.
Lord, the system which is devised by the corporation, my lord, is for any person whose pay is in the range exceeding 500, there needs to be a board meeting which will confirm their appointment.
Or obtained, and they are reluctant and denying to give you those documents, then you can approach in a different manner.
My lord,
Legally
in my
safe.
writ petition, that was one of the prayers.
Those documents are there.
My lord, in my writ petition,
Substantiate your
my lord, in my writ petition, those were the prayers, my lord. If your lordship will kindly take the prayers in my writ petition, those were the prayers.
अरे वो तो কথা বলতেই ব্যস্ত থাকে।
Well, writ petition. My lord would kindly take page 12 of the writ petition, my lord. Prayer B.
Number 3 to recite and order annexure P4 mentioning the overall drawal from the graduated.
My lord, this money I have received. This 386.99 I have received. That I'm telling on instructions when this order was passed, my lord, I was not there.
Did they ask you to refund?
My lord, what happened? They had initially stopped my pension and gratuity on the pretext that I have overdrawn my salary. And on that pretext, I attained superannuation in 2014. I filed a writ thereafter. Not this particular writ, my lord, there was another writ preferred by me earlier. In that writ, there was an order passed by the court directing them to immediately release my pension benefits as well as my retirement benefits, which I was entitled to as an employee. They didn't release my gratuity. The gratuity amount they deducted because they said there has been an excess payment of this particular amount, 386,999. Now, my lord, that is reflected in annexure P4. I moved this writ petition subsequent to the earlier writ petition. In the earlier writ petition, my lord, there was some cascading orders passed against the respondent number 3. There is an appeal preferred, but that appeal only dealt with the findings which were being rendered by the learned single judge. Insofar as the pension and other benefits were concerned, there was a concession from the end of the respondent number 3 that the pension and all other benefits would be given. And I have been receiving pensions thereafter. My only contention today before your lordships is, in light of the fact that I have already received this amount, which is 386,999, if they have accepted that this amount needs to be paid to me, then for the 5 years, the scale benefit that I was not entitled to, because of which there has been a reduction in my pension, because my lord knows the pension is 50% of your last drawn pay. So they have not given me the benefit of these 5 years because they say that you were appointed on an ad hoc basis and your appointment has been confirmed in the 37 minutes, which is a subsequent appointment and starts from 1988, and not in the 28 minutes which I have annexed, which shows that I have been appointed. So this is the case in a nutshell at this point of time. Now, my lord, insofar as what your lordship says that the records and everything needs to be transmitted, I had made a prayer. Now, they didn't disclose to me the 27 minutes. It's me who got hold of that 27 minutes. Now, this 27 minutes is also not denied by them. Because in the application that I have filed, subsequently, my lord, because if your lordship recollects, when I moved that application, they wanted to...
Appointed in the year 1980.
Initially as a junior technical officer. Subsequently, fresh appointment again happened in 82.
The 82 till 84.
No, my lord, not 84. I was being given time as a temporary appointment. But I was confirmed in the 83rd, I was confirmed on 22nd June 1983 in the 28 minutes, because the board essentially confirmed my appointment. And that is reflected, my lord, because I was appointed as a technical officer organization. Now, their reply, my lord, would kindly see what their reply is. Their reply is that there was no post of technical officer organization. So, your appointment was essentially on an ad hoc basis. Your appointment is not on a permanent basis. That is their contention. And on that pretext, they don't give me the scale benefit for the 5 years, which I was entitled to. And apropos that, my pension, which I am receiving today, my lord, is much lesser than what I am entitled to receive.
Where is that appointment letter of 88, wherein you had been confirmed?
My lord, 88 is the board's meeting, which they say. They have not produced that board meeting, that 37th.
That you had been made permanent.
My lord, I have annexed the 28 minutes, which I showed before your lordship. The 37 board meeting minutes, they have not annexed. They say I was appointed, given confirmation in the 37 minutes.
In any case, sir, both you had taken his services, sir. You are the one.
Yes.
Yes.
Right? So you cannot deny that he had not been an employee at your concern.
Yes. He-
So in which manner?
In
and
accordance
how,
with
sir,
what he
in
has
which
given everything.
manner, in which manner, and how he had been appointed, and thereafter whether it was on a temporary basis, and thereafter the order of making him permanent.
Again on temporary basis. What my learned thinks is far away of the truth.
So those, you
Yes,
please place
37
figures
years. My lord,
or
please.
those minutes, because the minutes over here, where what
37th meeting. Milord,
the meetings
nowhere
are
in
not
the world it is
witness
seen that a person has been given
whether he
promotion
had
after
been
2 years
appointed
of
or not,
service.
and at
It
all
was a
on what
temporary
basis.
post.
No, 37 minutes.
All these things, sir.
You
Yes,
with the-
yes, I will produce.
Exit
Milord,
Why are you getting so excited?
excited one after another. My learned friend was saying, Milord,
So
it's
you
not true.
don't bother what he's saying.
Yeah,
sir.
listen.
You have to explain
Yeah,
it to me,
no, yes, I
because I
explained.
need to understand.
I explained before Lordship. The petitioner joined in the year 1980 as junior technical officer. In the year 1982, there was a post. West Bengal Comprehensive Area Development Corporation was in the budding stage. It came into existence in the year 1977.
I've given you a lot of time. I have other matters also. In the meantime, you get hold of those copies, or copy of the orders as well as the minutes as you're referring to. Ashwin, how you will get it, you find out.
I've understood the query following from your lordship. Is your lordship keeping it this side of the vacation, my lord?
For the submission of the
এই ওটা আমার লেখা আছে না ওটা কাগজ দিন না এখান থেকে আর এখান ওটা আমার লেখা আছে কাগজ
So your respondent number 3. Respondent number 3.
I'm for the state respondents, my lord.
State has a role.
I think Finance Department is the controller.
May answering respondent.
Is Panchayat.
Yeah, the
Well, corporation is the answering respondent.
Disbursing authority.
Rightly so.
Corporation is the my lord, answering respondent, my lord.
Corporation. Simply executing.
The learned advocate representing the petitioner is to file a supplementary affidavit annexing the resolutions taken in the meetings referred to by him, based on which the appointment of the petitioner to have been on ad hoc basis as well as a permanent employee transpired. Okay, sir? Similar orders granting such ad hoc appointment as well as permanent appointment by the respondent number 3 are to be placed before the court on the next date of hearing. Next date be fixed on 27th of November. Yes. Learned advocate representing the state is present.
Idea that the entire office record has been transferred from Wellington Square to Salt Lake.
So you send somebody and ask them to find out.
Most of the papers I do believe with the corporation now. What my understand told you because I am also in the dark.
You have a copy of the writ petition.
Yes, I've seen it.
So you get the clarification therefrom.
Of course, I will clarify if my learned friend files a supplementary affidavit.
Okay. Next.
Governmental proceeding, my lord, the petitioner was punished with a
My lord,
of compulsory retirement. Last
So the
petition,
pleadings
my
are
lord, I placed to
completed?
submit.
my
My lord, I
lord,
want to file my written notes of argument. Lordship kindly
No,
keep it
the-
after vacation. I will file my written notes of argument.
Yes. So you had been given the last chance on the earlier occasion.
Very well, ma'am. After vacation, I shall file written notes of argument.
Why, sir? You're not been able to.
Before vacation, my lord, it is not possible. Because in a 3 or 4 matters, you'll say direct me to file a written notes of argument. So from Monday to Friday, my lord, I will have to file 3 written notes of argument.
On the prayer of learned advocate representing the petitioner. Who are you, madam?
ma'am, actually, my lord, my senior is busy in court number 4. He is appearing the court. Therefore, he asked me to take up short passover.
So let them come. They were also directed to file the written notes. You wait for some time.
Grateful, my lord.
So at 2 p.m., my lord.
Not 2 p.m., sir.
চা খেতে যাবো।
In any case, you wait here next if you don't have any other work. Next.
I am for the petitioner led by Mr. Sudipta Manda. My lord, last section, my lord, directed to file the
Affidavit and reply, yes. Chanchal. Affidavit and reply filed on behalf of the petitioners. We kept on record. None appeared to represent the state. The pleadings are completed. Next date be fixed on 21st of November for hearing.
Fine.
My lordship.
For the petitioner, your lordship.
My lordship, I am for the respondent, Transport Corporation. My senior is appearing virtually.
Your lordship, this is my reply, your lordship. This is the reply which is affirmed earlier because the erstwhile counsel appearing for the WBTC, they had filed their opposition. I don't know whether it was in my lord's record or not, but copy has been served upon me. The contentions taken in that opposition was the same, which they are filing right now, your lordship. So this was my affidavit in reply on that. The same to say the replica of the early one. So this is my affidavit in opposition. My reply, your lordship, sorry. Your lordship, this is the matter where I am seeking regularization of the service of the petitioner. The petitioner is an employee of the West Bengal.
This is a reaffirmed one?
Yes, my lordship.
Yes, my lord. My lord, I am appearing for WBTC. My lord, the direction was to reaffirm the earlier affidavit in opposition because, my lord, we had obtained it.
Yes,
itself
now,
from-
okay.
Lordship, this is the matter where I'm seeking regularization of the service of the petitioner. The petition is an employee of the West Bengal Surface Transport Corporation. Now it is WBTC, West Bengal Transport Corporation. So, your lordship, the factual aspect of the case is that, your lordship, on the earlier occasion, my lord has directed me to amend the cause title by adding the state of West Bengal as a party respondent. I did it, and I served the copy to the state, your lordship. Your lordship. Now, your lordship, what happens? The petitioner was an employee of the West Bengal Surface Transport Corporation. He was appointed as trainee driver bus, lordship, in 2001 on the terms and the conditions mentioned in the appointment letter. Now, your lordship, during his provisional period, he was terminated from service due to a criminal case pending against him, and it was a run-over case because he was a driver, your lordship. So he was entangled with that criminal case. Now, in 2013, your lordship, he was found not guilty of the offense, your lordship, and he was acquitted. And a fresh appointment letter was written to me, reinstating me in the service, your lordship. It was not my fresh appointment.
Where is that order?
The order, lordship. Kindly come to page number 24, annexure P4 of my writ petition.
Yes.
With reference to your application dated 7/3/2014, the corporation is pleased to reinstate you for the posted driver purely on contractual and no work, no pay. So my contention before your lordship, he was reinstated in his service, your lordship. So there cannot be a break of service, your lordship, because I was appointed in 2001. So in this writ petition, I have referred one
Contractual basis.
lordship. I was initially on contractual basis.
Now what are you claiming?
I am claiming regularization of my service after 10 years, more than 10 years of my service. So, your lordship, I have referred.
You have been denied?
Lordship, I was not denied. I was not accepted.
Did you file any representation?
Lordship, I have filed many representation. Kindly come to page number annexure. It is P5 annexure P5, page number 26. There it's a minutes of meeting, where your lordship kindly come to page number 28, which I am referring. And in the representation also, I have referred this. So kindly come to page number 28. Now, second last paragraph. The House perused a note of the MD containing the background and the present state of affair in the respect of 37 employees. The MD was authorized to absorb those who are getting monthly remuneration of lowest range rates against the contractual post of the driver contracted as stated under GO number this 2014. So, your lordship, I am claiming my regularization on the basis of this.
So now were you under these 37 employees?
Lordship, because at that point of time, I was among these 37 employees who are getting lower rates against the contractual post of the driver. So I ought to be, but I was denied. So I made a representative that has not paid any heed to. Now, your lordship,
what did they reply?
Nothing. I am still working as a regular driver. So, your lordship, there is no breakup of my service because I was reinstated. Since 2001, I'm doing the job of a regular driver, your lordship. They are not denying that in their opposition that I'm not performing my duty as a regular driver. So now, this lordship, I have referred this. Now, your lordship, I'm seeking the regularization of a service, and they say that there should be a policy of the state government. That's why I was compelled to add them, the state government, as a party respondent, your lordship. They say there is a policy, but I say, your
Those
lordship,
37 posts must have been filled now.
no, your lordship, that is not so, because I was praying for regularization because I come amongst those 37 employees who were getting lower.
No, but then how can you say that? It is for
Because at
them
that
to
point in
say.
time, I was among 37. They have taken from surface transfer. They have about 3 or 5
Who
employees.
can answer this? Can you? Yes, madam. Are you in a position to answer?
My lord, I'll try and assist my lord. My lord, firstly, my lord, the petitioner was a contractual worker. He was, my lord, in 2001, he was appointed in 2001 itself by the month of July. My lord, he was convicted. A case was registered against him, and for 14 years he has not worked. After 14 years, my lord, he was acquitted. So he was, my lord, again given a service. When he had made a representation, he was asked to join. So he had joined, but also in a contractual post in the year 2014. So, my lord, there is no question of continuity of service. After 13 years, my lord, the person comes and purely on humanitarian ground, he had been asked to join, that also in contractual position. He has joined in the contractual position and has been working ever since in the contractual position itself. And his contract is the governing document of his service. Today, he claims regularization. He claims regularization on the basis of a document which is not even of WBSTC, of which he is an employee. He is claiming a regularization on the basis of a document which is of CSTC, which is a different corporation altogether. As for regularization, your lordship, the petitioner, it is not the right of the petitioner to be regularized. As for regularization in these corporations, there are matters, my lord, which are pending before the Supreme
Now, when
Court.
this order was of absorption, as you said,
Reinstated.
37 posts.
37 posts were, your lordship, it was filled up in 2015, your lordship.
2015.
Lordship.
So you are,
Yes, sir, your lordship, I made a representation.
you have been reinstated in the year 2014.
Lordship, what happens, your lordship? I was appointed initially in 2001. When after 14 years, when I was acquitted because they do not fault any fault of mine by the lower court, your lordship. So I was reinstated in the same post. They made.
What was the word used? Reinstated?
Reinstated.
My lord,
what was the term? Reinstated or what?
The appointment letter says so, reinstated. E4. In the same post.
My lord, the letter
Where is that?
at page number
E4, page 24. The appointment letter of my lordship. E4, page 24. With reference to your application dated 7/3/2014.
Yes, to reinstate you in the
driver, what I was in 2001. So again, I made a representation.
My lord will kindly seize the document in its entirety. Not
earlier
just
also you were on temporary basis.
Yes, yes.
And now
of
also
course,
you
but
have been on temporary basis.
So since 2001, there is no breakup of service. Lordship taking the view that I was reinstated, not fresh appointment was given me after 13 years. So I'm covered by Uma Devi's case, paragraph 53. I was not backdoor appointment. I was given by appointment by a selection process. Everything was done. So I'm I'm seeking regularization of a service. I have shown my lord the resolution of 37 employees. I come under the purview of these 37 employees. I made a representation.
You are one of those.
Lordship, I am among those. And this surface transport has merged with the WBTC. What is right now, your lordship?
No, my lord.
So this
is completely a false premise.
Lordship, if that
yes, sir. What do you have to say?
I will not trouble you, lordship, much.
No, what would be the concept, the principle? Because in any case, you are the disbursing authority.
Policies have been taken by the respondent number 1, that we depend. But if they are regularizing few people, what were the parameters and if the petitioner fit in such parameters will be of the consideration. Otherwise,
Lordship, they have given that the state should make a policy. They are dependent upon the policy of the state government. In their opposition, they have made this contention. They do not have their own.
So that means still, as of now, there is no such policy.
Lordship,
As of now, there is no such policy. I mean, no such scheme to have been formulated. As far as contractual,
There are certain benefits that are extended to a contract.
no, but I believe the petitioner is still in service.
Lordship.
He's still in service.
He's performed the duty of a regular driver.
Your Lordship, by virtue of certain memos, certain benefits have been extended to contractual.
Chanchal.
employees.
37 employees were regularized.
Employees cannot be
I made a representation.
regularized.
So
By
they should
this-
taken the steps in my.
No, her contention is different. I mean, the period when the petitioner was out of service, and she is admitting that the petitioner was a contractual employee. And due to the pendency of the criminal case and its result in order of acquittal, there was a lapse of 13 years. She claims that there has not been any break of service,
As I
and
was
those
saying.
13 years should be counted.
I'm grateful.
My lord, may I only take my lordship to page number 24, that is the contract of the petitioner, my lord.
I've seen that. You
Yes,
have
my lord. My
the
lord, in
word
page number,
is to reinstate.
yes, my lord, I'm grateful. And my lord, in page number,
Madam,
page
you have to
number,
show whether reinstate. You come to that first line with reference to your application dated such and such. The corporation is pleased to reinstate you for the post of driver purely on contractual and no work, no pay basis. Afresh.
afresh. My lord, the word afresh. For a period of 6 months with effect from your date of resumption of duty under the following terms and conditions. Now,
Now
the terms and
reinstate and
conditions, my lord,
afresh.
will,
Again,
my
date
lord
of
will kindly,
resumption of the
yes,
duty.
now my lord will kindly
So
see
you
the
use
date of,
contradictory words in in
my
the
lord,
same
that has been
sentence.
used, my lord. I cannot
Pleased to
better, I
reinstate,
cannot better this
thereafter
document.
afresh, thereafter resumption.
My lord will kindly see, my lord, there is no continuity in service in contractual employees, first of all, my lord. This is a fresh document which had been, my lord, executed at the instance of the petitioner. Now, the petitioner's employment is on purely on this document that has not even been denied by the petitioner. Now, my lord, kindly see,
So you mean
the
to say,
petitioner has been,
madam, you mean to say the petitioner got himself reappointed on his own accord, issued the
no,
appointment letter? Then why are you saying
no,
it
no,
has
no,
been on?
no,
You
no, but
had
it
the
is only on,
you had the option, you had the gumption, you had every possible, I mean, your mechanism, your
yes,
will,
definitely, my lord,
your weight
definitely,
to have refused that.
definitely. My lord, the petitioner's employment is not in under question. The petitioner's absorption in a permanent
Yes,
of
the petitioner is
regularization is in question.
Let's see whether that can be possible or not. Okay.
And my lord will kindly seize one more thing, my lord, if I may show. Page number 25, my lord, the petitioner, the contract itself says the temporary engagement shall not in any way confer upon you any right to permanent position in WBSTC. This has also been accepted by the petitioner. So these are the terms and conditions on the basis of which, on the acceptance
Heard
of
the
which the
submission
petitioner
of
was
learned
given.
advocates representing all the parties. You file a short written note.
Lordship.
My lord.
Written notes of arguments be filed on the next date of hearing. Next date be fixed on 26th of November.
My lord.
The book. Yes.
My lord, item number 40, am I paying for the petition?
Mr. Amal Kumar Sen, London Additional AG, was appearing on behalf of CSTC. Now he is returning from this brief. Kindly give some time so that concerned department can appoint new advocate.
Lordship, the appointment has been already been given to Mr. S.C. Bihani on the earlier occasion, my lord, at said, your lordship. Lordship, may I place my case in a nutshell, your lordship, whether Mr. Sen's appearance is required or not. Your lordship, here also I am praying for regularization of the service of a person who as an employee of the Calcutta State Transport Corporation, your lordship. Now, your lordship, the petitioner was appointed in 2003. Now, your lordship, in 2007, 17th of September 2007, his name has been struck off from the payroll on the report submitted by the DIG, your lordship, intelligence branch. On the result of that, my name has been struck off from the payroll. For that reason, I have implemented the DIG intelligence branch as a respondent. So, your lordship, on the earlier occasion, the DIG has submitted a report. If my lord will see the report, your lordship, my lord will find that in 2007, they have filed one report that I am unsuitable for the job without assigning any reason on which ground I was made unsuitable. And after 7 or 8 years, your lordship, they came up with an application, they came up with a letter to the administrative personnel officer of the Calcutta State Transport Corporation that yes, I'm suitable for that. For there also, there no.
That is why an explanation was called for.
Yes, the DIG has given their explanation, and I say in the reply to that, I do not want to find any exception to that because their opposition says my reply also that there is no ground for suitability and unsuitability. So, your lordship, so my prayer is only for regularization of service since 2003. And the one more very important, your lordship, the point is that, your lordship, in 2009, CSTC has regularized 276 employees. But I was not taken into account due to that stuck off my name from the payroll. So this was entirely not fault of mine.
So what was the reason
The
cited by the
exact reason of not finding him not suitable and then suitable is not apparent. But my lord, I find from page 7, my lord will find this was the initial finding of non-suitable. Where my lord will kindly come to page 7. This is dated, my lord, 6 September 2006, my lord.
Yes, 6/9/2006.
The matter was inquired into. The inquiry report and verification role of the above named subject together with the connected papers are sent herewith for your favor and perusal and disposal from your end. It may be mentioned that the identity and nationality of the VR subject has been verified, but the study and date of birth of the subject could not be verified as the school in which the subject claims to have been prosecuted his studies is closed from 1996. In this connection, a report of the SBDIB by such and such.
So what was the qualification required? School leaving certificate.
Yes, lordship, they
So,
kindly see
the
the
school
next
leaving
page, your lordship.
certificate,
The
school
transfer
leaving certificate could not be what I gather, my lord. This is not from record, but what I gather, my lord, this at this, my lord, in the year 2006, the school leaving certificate could not be verified. That was the reason of finding him not suitable. That I can infer that much from this document, my lord.
I'll come to the next page, your lordship. Immediately
Because the school was closed in the year
No,
1996.
this document. Next page that you are.
Transfer certificate.
Yes, which school?
Your lordship, the school headmaster.
Which school? There is a certificate, transfer certificate from which school?
It is dated, my lord, kindly take note of the date, 5th May 1994.
94. So here, date of birth was written on 27/6/1975. Was not. Maybe this was in the record of the CSTC because in CSTC on the date of my appointment, I.
So now the name of the school is also not there.
Lordship, the name of the school will be there in the record of the CSTC, your lordship, because I've given all the certificates. Because what certificate is required for them, I have given them.
You should also know which school it
Lordship,
is.
it was all the documents of the they have gathered from CSTC. Only my date of birth was not verified. That cannot be the reason. No ground was given, your lordship. Only the ground the school has been closed in 1996. And after that, your lordship will see that I am found suitable. So they cannot blow hot and cold at the same time with the life of the poor employee, your lordship. It's very suitable. And
you also furnish a transfer certificate without the name of the school.
lordship, that I don't know because that can be the service record.
So whenever you can't answer, you don't know.
No, your lordship, that is not so, your lordship. The CSTC, but I have to give, your lordship. I am appointed, I am an employee, your lordship. Kindly come to page number 12. Annexure R6 of their opposition, Your Lordship. In cancellation of this department, memo number this and this, on the subject mentioned about to.
So, sir, according to you, the reason is incomprehensible.
It has to be inferred. I will kindly also take into consideration page 12. Here we are finding him suitable. So, my lord, I can.
Cancellation. So, if you have subsequently found him suitable,
Right. So, we have to infer that he was actually suitable.
because
My lord, we could not verify that document because the school was closed. But I have definitely.
but you did not dispute that the school did not exist.
They do not dispute.
You went and found that the school was closed,
Right.
and thereafter you could not verify the
today-
authenticity of the
thereafter,
document.
my lord,
But you did not say that the school did not exist.
Right.
That you did not say. School,
But possibly with
the existence of school was there.
No, possibly with the language of the school being closed is by this, my lord, the department wanted to mean that the school is closed. But, my lord, subsequently.
Closed means what? Was it a holiday or was it non-functional?
If it is
Or did not even exist?
If it was a holiday, my lord, my officer would have visited this
Right.
print. So closed has to be inferred that the school was not in existence in 96.
So not in existence in 96, not in existence would have been differently mentioned. It wouldn't say closed. It wouldn't have been closed then. It did not exist.
It did not exist.
If
It
the
did
school
not
wasn't there, it did not exist. But closed means what? It was earlier functioning, thereafter
Absolutely, absolutely, my lord. Now, my lord,
stopped functioning.
page 12 goes to say, my lord, that he was subsequently found suitable.
So what was the problem of the CSTC? Who should have granted, according to you?
That is the inference, my lord. I'll not.
You infer.
Sides, my lord, but that should be the inference. Legitimate inference should be that, my lord. Subject to my lord's approval, my lord.
Yes, madam. What do you have to say? I know, but then in what capacity are you there today before the court?
Can appoint next another advocate.
But I'm asking you, why have you come? In what capacity?
Yes, I
So he's not there, no longer there. Heard the submission of learned advocate representing the petitioner as well as, sir, you had been
State, my lord, your lordship.
state. None appear to represent the respondent, CSTC. I'll fix it for orders, madam. Next date be fixed on 17th of November for orders.
You're grateful, my lord.
I'm grateful.
And for the response 58, my lord. Paritosh Mandal. Paritosh Mandal. But again, they repeatedly. Oh, yes, my brother has come with an allegation. Your lordship, in this matter.
What is your name? What is your name?
Tanveer Mandal.
Then how come this Chiranjeev Sinha's name is appear in the list?
Your lordship would kindly recollect on the last occasion I have given my wakalatnama on the last date itself, and that was.
Yes, continue.
Your lordship, on the last occasion there was a direction to file the affidavit in reply, your lordship. That has been made ready, and this is the affidavit of service, your lordship. I have received it yesterday, my lord. Comrade Shimon is reading it.
You are representing the bank. Affidavit of service filed by the learned advocate representing the petitioner be kept on record. Affidavit in reply filed on behalf of the petitioner serving a copy of the same upon the learned advocate representing the respondent bank be kept on record. Now tell me, what is it?
My lord, I have a preliminary question with regard to maintainability, which I also submitted on the last occasion. So if my lord gives me the priority to make submissions, my lord, because
Tell me.
on maintainability, my lord is going to the root of the matter. If my lord is satisfied on the point of maintainability, my lord may not hear the matter on merit, my lord. It will save judicial time.
Yes, what is it?
My lord.
Your Lordship, Mr. Sen is leading me in this matter. Your Lordship, Mr. Samrat Sen is leading me in this matter.
My lord, admittedly, the petitioner is an award staff of the bank.
What staff?
Award staff means he's the clerk. The clerk of the bank, my lord. And he was, my lord. And what happened, my lord, in very recently, my lord?
Is he still serving?
Your Lordship, no. He's not in service. He has been terminated, Your Lordship, by compulsory retirement. That is the
compulsory retirement.
My lord, why I say this because, my lord, very recently in another matter, wherein the petitioner was or the appellant was rather the award staff or clerical staff of the bank, the division bench, the Honorable Division Bench of our High Court, clearly held that if he is a clerical staff of the bank, then he should approach the tribunal.
Do you have that decision with you? Do you have an extra copy? Give it to him. Where, show me the paragraph in which it has been stated that a clerk cannot approach the court.
Page 2, last paragraph.
Now you have to first of all define as to whether the workman and clerk are synonymous and whether the designation of the present petitioner fell under the definition of workman or not.
Admittedly, the petitioner is governed by bipartite settlement of April 10th, 2002. My lord, kindly see paragraph, page 2, plus the last paragraph of this order. Undisputed fact is that the appellant is serving as a senior associate in a respondent in the State Bank of India. It is not in dispute that the appellant is a workman as defined under the bipartite settlement dated such and such and in terms of section such and such of the Industrial Dispute Act, right? 58 of the.
Right, so it has to be seen as to whether the petitioner.
This is the repetition. I'm not.
Which page?
This is the repetition. Yes, and page 72. And here it is admitted also. It's governed by the bipartite settlement.
Page 72.
The bipartite settlement is a copy of the bipartite settlement.
Yes.
Volume 1 of the repetition.
Which page?
Paragraph 3, my lord, can you see?
Which page, sir?
3 of the repetition, paragraph 3. Big body of the. I will come to that later, next later.
Yes.
Your petitioner joined the services of State Bank.
Okay, your petitioner is a workman. Within the meaning of Industrial Disputes Act, your petitioner
is governed by the bipartite. So it is admitted. I do not read.
Okay, so on the you forward this copy that you have reserved to your senior on the next day, please. Ashok. The learned advocate representing the respondent bank has raised the issue of maintainability of the instant writ petition based on the decision of the division bench of this court in APOT 342 of 2024, wherein this division bench had refused to entertain a writ petition filed by a workman under the working under in State Bank of India. Defined under the bipartite settlement dated April 10, 2002 in terms of section 2P and section 18(1) of the Industrial Disputes Act 1947, read with Rule 58 of the Industrial Dispute Central Rules 1957. The learned advocate representing the respondent bank referred to paragraph 3, 4 and 5 of the instant writ petition, wherein the petitioner had affirmed to have been a workman. 3, 4, 5 and 6 করে দেন। Workman within the meaning of the Industrial Disputes Act 1947. In paragraph 5 and paragraph 6, reference to the aforesaid bipartite settlement has been confirmed. The learned advocate representing the respondent bank has handed over a copy of the decision passed by the division bench of this court as aforesaid. Next date. You are the advocate on record. Next date be fixed on 20th of November for hearing on the point of maintainability. So you so that they are it itself we can dispose it of. Next. Yes, sir.
Has not.
Ashun. The learned advocate representing the petitioner sought time to file the written notes of arguments, stating that he could not prepare the same since time has been consumed by him in preparing written notes in other writ petitions. None appeared to represent the respondents, nor written notes of arguments had been filed on behalf of the Respondent Union of India. Next date we fixed on 21st of November.
21st of November.
You get sufficient time for filing written notes? What about FMA matters? All of you are there?
For orders, yes.
For orders. Yes. Yes, you're ready with your files for orders. Kintu,
263 is my appeal and 264 is my learned friend's cross objection, my lord. I have preferred this appeal mainly on the ground that the driving license was not valid to drive the offending vehicle on the date of the driving license of the driver. And we had also adduced evidence. My lord will kindly come to
your only contention is the driving license.
driving license.
Which page?
Was not aware. But then again, the motor vehicle inspector, he was and he confirmed that the driving license was not valid on the date of 19. So on the basis of
19.
Page 19, on the basis of the motor vehicle inspector, I pray for that pay and recovery order from my lord.
No, I cannot say from my record that whether it has been renewed or not.
Yes, the immediate line before that, the driving license of Indrajit Singh for heavy goods vehicle.
It was valid
Was still,
till
yes.
19.3.
And the accident took place, my lord, on 7th of August 2010.
So the next line is,
Yes.
I cannot say from my record.
I'm sorry, 6th of July. Yes, from his maybe, but it was it's apparent that it was not valid.
Say so. Your apparent. I cannot say from my record that whether it has been.
It was renewed or not. That he is not aware of.
Then,
but whether it was valid or not, it was not valid on the date of accident. Regarding the renewal portion, there is a confusion.
No, the said license in the cross objection, the
Yes.
said license has been computerized.
My lord.
I do not know it. It is then might have a valid license, driving license.
Yes.
Have you taken this point before the tribunal?
Yes, this is my evidence. He appeared.
No. What did
my
the
lord.
tribunal say on this?
I'm coming to that. at page 24. Starts at page 24 is the relevant paragraph. Tribunal took note of that evidence of the owner who said that he was not aware whether
Which paragraph?
page 24, the first paragraph. It starts from there. And held that the driving license was valid. DW1 is the owner of the truck who admitted that on 6th of July 2010, he was the owner and Indrajit Singh drove the vehicle. He stated that he had no personal knowledge whether Indrajit Singh possessed driving license at the relevant time. Be it mentioned that DW1 is deposing after about 10 years from the date of accident.
On the other hand, the charge sheet is on record, which reveals renewal slip of driving license valid till 19/3/2013 was seized. Exhibit 3's then.
I'll just check. I may have missed.
Yes, Chanchan.
And
what are your points? Have you filed any which page? Yes. Then second. Then page 62.
Main page is my lord, 69.
69.
Bottom folder, what give? Uh, uh,
1,40,000.
1,40,000. Thereafter, my lord, there was a other source of income 54,000. And competition income rupees 1,94,000.
Yes. 1,83,630. 6A, it was deducted. You mean to say that that deduction was not correct?
No, that deduction is not for rebate has been given for assessing tax. The income tax is one of the first net refund.
So you mean to say 194,000?
194,000 minus 6.
What did the tribunal take? Hmm. Now show me that chart sheet. So you keep it in mind as I am dictating, you point out the pages and the exhibits too. An application under section 166 of the MV Act had been filed by the claimant on account of the death of the না না এটা কোনটা হলো 262 তো তাহলে ওটার অর্ডার হলো না 262 না না আসুন 262 none appeared to represent either of the parties. Next date be fixed on 11th of September for orders. Next. Yes.
The injury case lawsuits, the 40% is disabled person. The medical board issued the civil certificate. Come and depose. And lordship, the learned tribunal, I have come only the issue of quantum. The learned tribunal did not apply the multiplier method. Lordship, kindly come to page 152 of my paper.
So you had relied on this judgment.
Hare Krishna Mahaprabhu.
Yes. And then you
The learned tribunal given 6 months income, but
according to you, this attendant charges and medical charges are not required.
as well as lordship, the multiplied method not applied.
The diet and transportation are not required.
I am not placing that.
And multiplier 40%, this is also not required.
Considered, yes.
Acha. Then why have you come?
I am come lordship, the income assessed by the learned tribunal, so that they should apply the multiplier. They did not apply the multiplier. Only 7 months income awarded. Medical expenses I am not disputing. And lordship, pain and suffering is given 2 lakhs.
She was a teacher, if I'm not wrong.
No, he is a he lordship. Not he was not the teacher. He was the serviceman. Now he's unemployed.
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 If you wanted to be unemployed, then I'm not going to say much. Yeah, after 7 months, he has become okay. He has joined service, doing service very much.
In
This
which
is-
service?
Yes, this is his statement.
Where is it?
Page 20 of 70. It is the fact that I have received all not payment.
Yes, yes.
Yes.
It is a fact that I've received all payments as shown in compensation details, Exhibit A, excepting for 7 months. That is from the month of September
Yes.
2014 till March 2015, during which I was under treatment after the accident. It is fact that after accident, I did not get my salary for 7 months from my employer.
Yes.
After my accident, I again joined my employment with Videocon, such and such. And since then, I received my salaries up to 9th of March 2017.
Because he has left the job. And after again, this is the fact.
Okay, if he has left the job, that is up to him.
Yes.
And you simply says he's unemployed.
Yes, lordship. Yes, evidence is now is after
And
that
also-
he's at
And also logically,
Lordship,
one just evidence, my lord. He's totally fit. Page, my lord, only just logically see the page, the last, my lord, the game, my lord. I see.
I have no documents to show that I need 5,50,000 for my future treatment. I've received reimbursement of medical cost of rupees 2 lakhs from the insurer of my employer against the gross medical expenses of rupees 13,50,000.
But he has not produced any type of bill, medical bill. He has admitted that, page 21, man.
That part I am not. Oh,
No, but given that we have no objection, man. But he has produced any bill. Only 7 months salary he has lost. Only 7 months. After that, that is will come 21,000, 17,000. Only 7 months. After that, he has joined the service. He has doing his work merrily, and he's fit. Page to 22, last page. This is independent witness, my lord. He has got the medical bill, page 22. I am the owner of medicine shop, such and
Yes,
such.
it is fact that patient Joy Narayan Shingaroy at present visits my shop to purchase medicine.
Merrily, and he's riding the motorcycle at the time.
Yes.
Yes.
Patient Joy Narayan Roy had last visited my shop about 10-15 days ago, and he visited my shop by driving his motorcycle.
Yeah, the case I have filed, the consider from the cause of action as in the accident happened. On that occasion, he was not even to riding the motorcycle. After that is developed, if he will deteriorate, then what will happen? After that will come with a claim application, so that perpetuity cannot be going on. On that occasion, he was received severe injuries. He was the patient. The doctor has issued after thorough treatment is 40% disablement. But Lossi Mali after 2 Lossi.
I was wondering why these people are here. Then I saw the
The kind of not alarm bell. This matters at 2 o'clock. Grateful to you.
the original side is there.
Yes.
After getting over with the original side, I'll continue with
Very
your matter.
My lord, very good. My lord.
Because in any ways, the criminal revisional applications are not very regularly being taken. Yesterday, the attendance was poor that way. লিস্টে আছে নিয়ে নিন একটা ডেট দিন ইয়েস স্যার
My lord, may kindly see the last order dated 13th of June 2025. My lord was pleased to direct the respondent authority to file a report in the form of an affidavit. My lord, to that extent, my lord, advance copy was given to me and I have taken out an exception to the report.
My Lordship, and for the Transport Corporation, my Lordship, my senior Niladri Bhattacharya is out of station because some professional purpose, so I'm praying for not today, my Lordship. We have filed the report, my Lordship.
The exception I'm seeking leave to file before lordship.
My lord, I beg to for the state respondent, so that your lordship directs the copy is out upon us. Will they have not received the copy of the report?
which one report
Yes.
why haven't you given them the report
I'm giving my Lordship.
There was a direction.
he has only come to seek for an adjournment where is the copy
We have served to Shantanu.
you have filed the copy of the exception
Yes, my lord.
I filed the exception right
Yes, yes. I have taken a
We have
exception.
served, my Lordship.
The exception filed by the learned advocate representing the petitioner in compliance. Order dated, when were you directed to file the exception?
My lord, order dated 13th of June 2020.
13th of June 2025, be kept on record. Have you given them the copies?
Yes, I have served.
Are you yet to serve them? Or you have already served them?
No, I have served the respondent number 2 to 5.
Corporation
But so far as the state is concerned, my lord, I will serve by in course of this week or today itself.
Okay. The learned advocate representing the petitioner submitted to have served a copy of the exception upon the learned advocate representing the respondent number
225.
225. State is respondent number 1. He is yet to serve a copy of the same upon the learned advocate representing the state and undertakes to serve the same during the course of this week.
My lord.
Okay. Next date we fixed on 14th of November.
Number 2.
It was filed with the lordship. It was handed over to the Banerjee, your lordship. And they were supposed to file a reply to the supplementary affidavit with the further instructions for some clarifications from the respondent number 1, 2, and 3, your lordship.
Mr. Siddhartha Banerjee is representing the High Court administration in this matter. Mr. Banerjee is on his legs before the division bench representing the High Court administration, my lord. I am praying for a very short passover, my lord.
I have appellate matters to be appellate side matters are there.
Some other day, your lordship. Banerjee is.
What is your issue? Just tell me for recapitulation.
The petitioner is a retired judge from the City Civil Court at Calcutta. Super time scale of was allowed.
Oh yes. Okay. Yeah. You must not know about the matter at all. There was a direction to file certain
There was direction to file
clarification from the Register Judicial Service, I believe.
There was a direction of 28th of July of your lordship's order. Next date we fixed on so and so for seeking clarification by the learned advocate representing the respondent number 1, 2, and 3 from the concerned authority. So my learned friend
Your super time scale grade was denied.
was denied.
So they had grounds for that also, sir. They must have stated grounds for denial.
Your Lordship. It was allowed by the single bench, Your Lordship. Then an appeal was carried by when learned friends client before the Honorable Division Bench, and the Honorable Division Bench clarified.
May I make a humble prayer, Millard? I'm sorry to interrupt. Millard, there is a division bench matter where, Millard, I am representing High Court administration, which is, Millard, with regard to, Millard, framing of a rule. Millard, may I, Millard, come back any other day? Of course, Millard, subject to Millard's inconvenience. Millard, I am a little, Millard, held up. Before, Millard, Justice Show mentions, Millard, division bench.
You come after vacation then. The prior
Very
to
well, Millard. I'm so grateful. Very well, very well. So grateful, so grateful.
Have you obtained the clarifications?
Millard, to some extent, Millard, I have. Millard, I have asked for some more. Millard, I'll come back. Millard, I take my lord's kind leave, Millard. The Honorable Division Bench is sitting. I take your
Yes.
lordship's kind leave. Grateful, Millard. Great.
The learned advocate representing the petitioner is present. On the prayer of learned advocate representing the respondent High Court administration to have been indisposed of to attend this court due to his engagement before a division bench. Next date be fixed on 21st of November.
First of November, Your Lordship.
Lordship, I'm representing state, Your Lordship, in this matter. Led by Miss Sinha, state for the state, Your Lordship.
Number 2 PM কোনো ফিক্স নোটিস আছে তাহলে পাঠান
So there's a 2 PM fixed matter in the appellate side.
which matter?
Assign matter.
Assignment.
Number
317.
317.
But sir, prior to that, there's a part-heard matter. So let the 316 be called first
Sure.
and thereafter.
217.
317.
Part matter.
Okay.
I'm for the response.
That additional issue was framed. Substantive, sorry, not issue, substantive question.
My lord had heard me, my lord, on the other points regarding substantial question of law, my lord, written notes of argument and the judgments are already with your lord.
Yes, the moment they started, they raised this issue. Your other side.
Now, my lord, kindly see your lordship's order dated 8th of July 2025.
8th of
July 2025, my lord's order.
Yes.
Kindly see, my lord, the second paragraph, the additional.
Whether no. Timantha. এটা আপনি নিয়েছিলেন তো দেখুন নন জয়েন্টার এন্টার নেই there is a spelling error, it should be corrected.
The kindly see the second paragraph, my lord. The additional substantive question that would be substantial question of
Substantive.
is framed as question number 3.
Whether it will be non-joinder
of a tenant in common would affect the merit of the instant suit with regard to the tenanted property in dispute. Well, this was framed, my lord, on the, my lord, submission made by Mr. Chatterjee. Now, my lord would kind enough to come to the, my lord, paper book.
Yes.
that my lord would kind enough to come to page 18. Or rather, page 17 of the paper, decision with
Yes.
Can we see what were the issues framed at the bottom? One is the issue, is the suit maintainable in its present form and where?
Yes.
Has the plaintiff had any cause of action? Number three, has the plaintiff served notice upon the defendant? If so, what is legal, valid, and sufficient? Next, do the plaintiff definitely require the suit premises for use and occupation of himself and family members? It is the plaintiff entitled to get a decree as spread for what are the relief the plaintiff are entitled. Now, my lord, during the course of argument, my lord, they did not press, my lord, for my lord, this issue, my lord, to be framed. Whether
But sir, in paragraph 1, I mean,
that
under
I was
issue number 1,
coming. The next I'll read this. Kindly see, my lord, may I place the
as such, the present.
Yes, yes. Admittedly, the defendant number one, Prabhunath Srivastava.
No, prior to that.
The learned issue number one, Miller. Let us discuss the above issue. Issue number one. The learned lawyer of the appellant defendant pointed out that one of the daughters of the deceased of Om-Naran Srivastava has not been made a party in the instance. She is a necessary party to the suit.
So this is their contention now also.
Now, I will show to your lordship. As such, the present suit is bad for non-joiner of necessary parties and the suit is not maintainable. Admittedly, the defendant number one, Prabhunath Srivastava, and deceased Om-Naran Srivastava were the joint tenants in respect of the suit premises as described in the schedule of the case. It is also the admitted fact that the Om-Nath Srivastava died leaving behind him, surviving his widow, Srimati Shongita Srivastava, defendant number two, one son, Sanket Srivastava, defendant number three, daughter, Neha Srivastava, defendant number four, and another daughter. It is also admitted with a kindly below this marks this word and another daughter. This
Yes, it's already marked.
It's a fictitious not another daughter is coming, I'll be arguing on that. It is also admitted fact that said daughter has not been made party in the suit. Let us see who will inherit the tenancy on the death of the tenant. As per section 2G of the West Bengal Premises Tenancy Act 1997, in the event the date of tenant is his spouse, son, daughter, parent, or the widow of the 2G is virtually quoted here. Parent of and the widow of the predeceased son who are ordinarily living with the tenant up to the death of the tenant as the members of the family were dependent upon him and who do not own or occupy any residential premises will inherit the tenancy. So we have to see whether the second daughter of Om-Nath Srivastava was living with him as a member of the family at the time of death or it should be on. PW1 in his cross-examination has categorically stated that the eldest daughter of Om-Nath Srivastava has not been made a party in the suit. He has also stated that the daughter had been married long ago. DW1 in his cross-examination has also admitted that the defendants, namely Prabhunath Srivastava, Saket Srivastava, Sangeeta Srivastava, and Neha Srivastava, reside in the suit property. So, from the evidence of DW1 and from the evidence of DW1, it is clear to me that the present defendants are only residing at the suit premises and the eldest daughter of Om-Naran Srivastava has been married long ago. So we can safely presume that at the time of death of Om-Naran Srivastava, his eldest daughter was not residing with him as member of the family. So, as per definition of the West Bengal Premises Tenancy Act 1997, the eldest daughter of Om-Naran Srivastava will not inherit the tenancy of Om-Naran Srivastava and he cannot be put by the tenant. Therefore, the eldest daughter is not a necessary party to the suit. Besides that, there is no specifically in the written statement filed by the defendant the eldest daughter of the Om-Naran Srivastava the necessary party to the suit. So the appellant defendant are not entitled to raise the fee at a later stage. Thus, we have found that the present suit is not bad for non-joiner of necessary parties and accordingly the suit is maintainable. Now, this was also the finding of by the learned trial. This was the concurrent finding. Now, the appeal court's judgment, has gone against me. That's why I have preferred the appeal. Now, Lordship knows that the settled principle of law. Now, Milord, if the judgment, Milord, goes, Milord, against a person, he has to prefer an appeal. But if the judgment goes in favor of a person, but Milord, some of the findings, Milord, are against him, he has to file, Milord, a cross objection. Milord, here, Milord, no such cross objection. Either, Milord, order 41/22 has been filed, Milord. Therefore, how far, Milord, this issue can be raised by the Milord defendants at this stage, my Lord will kindly consider. Now, Milord, my Lord would kind enough to take up the written statement filed by my learned friend before the trial court.
ট্রায়াল কোর্ট রেকর্ড থাকবে
না একটা বাঞ্চ দেওয়া হয়েছিল
পাঁচ তো থাকবে
photocopy and give a bunch to your Lordship, Milord. I do not have extra copy. That will.
Yes, written statement.
Yes, my Lord would kind enough to come to
Page 6.
Page 2, para 6.
Yes.
And it comes to the defendant states that late Brahma Prasad Srivastav, the defendants of the father of the defendant number 1 and his younger daughter Purna Srivastav, husband of the defendant number 2, and father of the defendant number 3 became the tenant in respect of the ground floor of premises number 4B, Muktaram Babu Street, on under 1 Vijay Krishna Sarkar, and the then owner of the said premises. Therefore, who became the tenants? The defendant number 1, his younger brother, Omnath Srivastav, defendant number 2, the father of the defendant number 3 and 4. Therefore, it is the admitted case who have been 1, 2, 3, and 4 who have been made parties in the suit, the constituent judgment against suit, they have only become tenants. This is their admitted case. Now, Lord kindly comes to page 3, para 10.
Yes.
The said Omnath Srivastav died on 17th September 2002, leaving him surviving his sole widow, that is defendant number 2, the one son, namely defendant number 3, and another daughter, defendant and daughter defendant number 4 as tenants residing with him, and the tenancy became joint tenancy of the defendants, though the rent receipts were issued in the name of defendant number 1 and 2 for the sake of convenience by the plaintiff at the enhanced rate of rupees 400 monthly. Again, repetition, defendant number 1, 2, 3, and 4. There is no mention, Milord, of the other daughters, that fictitious daughter. Now, Milord, kindly see the cause title of the plaint.
No, you mean to say that the another daughter that
at all existence, that is not the finds place in the written statement.
that another daughter has not been specified anywhere without a name, neither it is mentioned in the cause title even.
Cause title, Milord, it has been our case, our plaint. They may say that your cause title is not binding upon us. But what is your, may I ask myself, what is your case in your written statement? You said defendant number 1, 2, 3, and 4 are the joint tenants.
And you had impleaded them as a party?
As a party. kindly see, my lord, once the cost side, my lord, what is the case of the made out in the plate one, my lord, kindly see.
Prabhunath,
Prabhunath and
Sangeeta, Sanket,
kindly see that Prabhunath, and after 2, 3, and 4, my lord, kindly see, my lord, Omnath Srivastava. After 2, 3, and 4, kindly see late Omnath Srivastava. They are the heirs of Omnath Srivastava.
okay.
Therefore, Prabhunath
So
and Omnath,
Omnath Srivastava was the original tenant.
Prabhunath and Omnath were the joint tenants. After the death of Prabhunath, our case is Sangeeta, who is the widow, Sanket is the son, and Miss Neha Srivastava is the who are the daughters of late Omnath Srivastava. They become the joint tenants. Now, in their
Then what happened to Prabhunath?
Prabhunath is also there.
So
Along with Prabhunath, these 2, 3, and 4 has
2, 3, and 4 are the
joint tenants with Prabhunath.
wife and the daughters of.
Son and daughter.
Sorry,
Wife, son, and daughter. Late Omnath.
but Sangeeta is the wife.
No, Sangeeta is the wife, widow.
Sanket is the son.
Son.
And Miss Neha is the daughter.
Known to us. They say another daughter, the eldest daughter. But no specification in the written statement who is the eldest daughter, name of the eldest daughter.
Okay.
Who are they? Will not take. Now, my lord, I have an alternative answer. Let us suppose, my lord, there was a daughter. Let us suppose. Although I am not admitting, this is my alternative answer. Now, my lord, kindly see, my lord, section 2G of the West Bengal Premises Tenancy Act.
And ছোট ছিল ছোট আছে ছোট আছে
This is what Millard now I'll submit is my alternative case. Kindly see Millard the definition Millard of tenant in section 2G.
Yes.
Kindly see tenant means any person by whom or on whose account or behalf the rent of any premises or is but for a special contract would be payable and includes any person continuing in possession after termination of tenancy and in the event of death. This is the catchword. And in the event of death of any tenant also includes for a period not exceeding 5 years from the date of such tenant or from the date of coming in force of this act, whichever is latter, his spouse, son, daughter, parent, and the widow of his predeceased son, who were murdered. Therefore, therefore, these are the 3 conditions which has to be fulfilled to get to be declared as a tenant under section 2G. What are the 3 conditions? Can we see, Miller? Who were ordinarily living with the tenant up to the date of death of the tenant. This is the first condition as member of his family and were dependent upon him. This is the second condition, and who do not own or occupy any residential premises and in respect of the premises let out for non-residential purpose. We are not concerned with non-residential purpose because this is a residential tenant. Therefore, there are the 3 conditions have to be kept in order to become a tenant under section 2G. 1, he has to be living. He has to live with the original tenant on the date of the original tenant, dependent upon him. And the third one is he or she does not own any residential premises of his or her own. These are the. Now, kindly, Lordship would kind enough to come to the key.
না এটা পেপার বুক থেকে বার করে দিন। ইস্যু নাম্বার
Yes. Now, Milord, kindly see, Milord, on this, Milord, the
Page 19.
page 19 of the paper book. Kindly see. Kindly see, Milord, where I stopped, Milord, on the date of not, Milord. First paragraph of page 19, then, Milord, may I place, Milord, read the next paragraph. PW1 in its cross-examination has categorically stated that the eldest daughter of Omnath Srivastava has not been made a party to this. He has also stated that the daughter of has been married long ago. Long ago. Therefore, he was, if at all, Milord, if there was a Milord, live daughter, Milord, we say this is a fictitious person. There was no other daughter. If there was a live daughter, Milord, she was married long. DW1 in his cross-examination has also admitted that the defendants, namely Prognath Srivastava, Sanket Srivastava, Sangeet Srivastava, and Neha Srivastava, reside in the suit property. So, from the evidence of PW1 and from the evidence of DW1, it is clear to me that the present defendants are only residing at the suit premises, and the eldest daughter of Om Narad Srivastava had been married long ago. So it can be safely presumed that at the time of death of Omnath Srivastava, his eldest daughter was not residing with him as his family member. So, as per the definition of West Bengal Premises Tenancy Act 1997, the eldest daughter of Omnath Srivastava will not inherit the tenancy of Omnath Srivastava, as he cannot be treated as a tenant. Therefore, the eldest daughter of daughter is not a necessary party. To besides that, there is no specific link in the true statement filed by the defendant that the eldest daughter of Omnath Srivastava is a necessary party to this suit. So the appellant defendants are not entitled to raise the plea at the later stage. Thus, we have found that the present suit is bad for
Not bad.
Not bad for non-joiner party. That this is Milord on Milord the second substantial question, third substantial question of law, which Milord instance of my learned senior friend, Milord Milord has been pleased to fix. Now, Milord, kindly see, Milord.
Is it here?
No, that's
Provision statement is
no.
Anything else you have to say?
My lord, this is the affidavit in chief.
Which you more?
Prognath Srivastava.
No, one not
One. Affidavit number
Examination in chief.
Yes.
Defendants number one.
One by Prognath Srivastava. Yes.
Wait.
Prognath.
Yes.
Kindly see page 3, para 6.
Page 3.
Yes, para 6.
Read it up just.
Yes. I state that my younger brother evidence on affidavit of Prognath Srivastava.
Date. In chief.
Chief.
Yes, page
Page
3, paragraph 6.
Yes.
I state that my younger brother.
My younger brother, Omnath Srivastava, died on 17th September 2002. His legal heir, his wife, his son, and daughter, not daughters. not daughters, only daughter, became joint tenants through the rent receipt were issued in my name, though the rent receipts were issued in my name and in the name of defendant number 2 for the sake of convenience of the plaintiff at the enhanced rate of rupees, my lord. Therefore, my lord, it is their positive assertion in their affidavit in chief. There was only one daughter who has been made party in this, not daughters. And I could not find, my lord, in reading of the entire, my lord, affidavit in chief, my lord, any further, my lord, statement in this regard has been made.
So now your issue of fictitious daughter is negated by the fact that the daughter was long ago married.
If at all exists.
If at all exists.
Because in the written statement, they don't say, my lord, they have, the Progunath has a, my lord, another daughter.
Nonetheless, they say that the daughter had been married long now. And you have not seen the daughter. So you have seen only one daughter.
Who have made part.
And accordingly, you have impleaded her as a party. Right? Accordingly, you have impleaded her as a party. And okay. And Prabhunath himself acknowledged that there was only one daughter residing at the tenanted premises.
Yes.
In exclusion of the other daughter who has not been described to have been married.
Now, my lord, lordship would kind enough to come to, my lord, the cross-examination of DW1 dated 24th March 2010.
Yes.
My lord, second page, my lord, our time.
Yes, tell me.
We the defendants.
We the defendants. We the defendants, namely.
Prabhunath Srivastava, Sangita, Saket, Neha residing the suit property. Residing the suit property. Therefore, even if there was an eldest daughter of Prabhunath Srivastava, he was never the resident of the suit property, at least on the death of the original tenant. Therefore, how far the he can claim tenancy in view of section 2G, my lord will definitely consider.
Okay, we'll keep it till here because we are running short of time today.
Conclude. My lord wants to give a thought on this point.
Those portions that you had indicated, because to again search it out.
And along with, I'll teach me not the plain written statement to this.
Yes, because the condition is appalling.
I understand.
Very torn condition. Even our records are not tearing apart.
Then also you people are dragging it with a lot of alacrity.
Second appeal, my lord, there are a lot of questions, my lord.
Not last.
Not the two. So I'm to the so complete. তোর কমপ্লিট নেক্সট দিন আমি বলবো সেটাই রেকর্ড করে দিই কি বলার আছে
এখানে দুটো স্পেলিং ভুল করেছে
পরে ভালো মামলা পেয়েছিস বলে এমনি করবি হ্যাঁ
for the submission of the learned advocate representing the learned advocate representing the present. Next date is 18th of November.
My lord, he has completed. My lord, kindly record. Then I will only answer to this.
Yes.
I'm on behalf of the petitioner, Lordship.
Who is the state?
Mr. Ganguly.
Where is your report, sir?
The report was filed.
Report was
there-
filed.
Yes. So that was filed that your lordship will find Lord in
Date,
Lord's order
February.
recorded. But that is 23rd of April 2025. না সাবমিট হয়েছে 23 তারিখ 23/4/25 কোর্টের অর্ডারে রেকর্ড করা আছে
Whether the crops are still preserved.
It has been preserved, that has been created over here, proper Jipon number, these two dates, diverse dates, 29th of April
No, no.
2023 and of 10th May 2024.
Which paragraph, sir?
देखिए ना होता
The second paragraph of the first page, on 29th. That report
বলতে হবে না
12th February.
এটা
25. 2 pages. Or 3
They
pages.
are asking to allow them to get the crops.
If you lordship directs with the Chimbalama details to why we are proceeding, both are claiming that this is a land belonging to them. Ultimately, whatever is decided, if it is decided that the crop has been.
You have the crops with you?
Well, that is what the report says, but
পেরিশেবল না সেটাই জিজ্ঞেস করছি ইট ইজ পেরিশেবল
this report says, well, I'll take the latest instruction, that whether this has been
Whether he is entitled to it or not is secondary. Primary, have you kept it in proper condition?
I have no idea of that.
That has been instruction.
How,
The thing is that
how many lordship?
But I have a question about the maintainability of the writ petition at the instance of a petitioner who challenges not a seizure. If he is not challenging a seizure, but he has to go before the concerned magistrate and say that there has been an improper seizure.
No, he wants to get his title decided
Then
through
God
the
has
writ
to go to
petition.
the civil court and because
I
can
think
show
so.
before your lordship
Otherwise,
that
what,
is Patta
let
was
us
cancelled.
come to his prayer in the writ petition.
Yes, Lord, that is at page Lord 8. Patta was cancelled and thereafter, Lord, he did not challenge that even.
Because, sir, direct the respondents to conduct a fair and impartial. Now, directing the respondents concerned to return the sale proceeds of the crop seized from the petitioner.
So these are
Now,
the
whether it
prayers-
was seized or not,
it is seized because that they have annexed documents in the writ petition to say it was seized. It was seized on the basis of my complaint. That is also on record. Now, Lord, whether the
seizure
seizure
of
was
petitioner's
proper
crop
or
and
not,
take necessary action against the persons. Direct the respondents to ensure the protection of the petitioner's land and crops.
that is, Lord, they have
Disputed fact.
Disputed fact.
Whether it's petitioner's land or somebody else's land.
Admittedly, it is a government land because they are holding patta according to their own statement. And I say that the patta has been cancelled by the government and returned to my client, who was not the original owner of the land, pursuant to the orders of the court. So as of today, Lord, their status is that of Lord a cancelled patta holder. So this, Lord, is a question which has to be gone into by Lord, not
Civil
the High
court.
Court, but a civil court.
But while I am in position, can they interfere in my position without having any order from the civil court?
No, your prayer is against, your grievance is against whom?
Police and private respondents also, because police are being influenced by the private respondents, and one of private respondents is the ex-minister and municipal chairperson of the Malda English Bazaar municipality, and because his influential, police has nothing to do, and police has continuously harassing us. We are the poor citizen, and also they are doing tactics. How they have filed, inspector filed the
When did you
report.
file the complaint? Your
Yes.
complaint is dated? When did you file the complaint?
Yes, definitely.
What is the date of that complaint?
Okay, I will tell.
Government is civil.
Lordship, 57, IC 54, page 54.
Complaint is dated page
No,
54.
no. IC Malda Police Station 13 May 2024. নিবেদন এই যে নিম্ন তফসিল বর্ণিত সম্পত্তি আমার পাট্টা মূলে
Seize the crops. It is, which is the date?
29th November 2023.
Which is the date?
So at the very first page, 29th November.
When did you file the report, sir?
That is of report has been filed on 12th February 2025. Report date. It has been filed on.
Reporter copy টা কোথায় হবে?
So I will hand over mine to the slightly digital box cannot be filed on the court.
My patta is page 12 to 17 patta. I'm holding the patta and I am cultivating the land, and my father's cultivating the land for 70 years, Lordship. Kindly consider that.
Yes.
And I would like to show one case.
70 years এখানে 12 বছর লিখেছিল
29th November 2023.
More than 70 years.
And thereafter, on 10th
We have been,
24.
our patta has been issued 2006, 2003. 6 October.
On both occasions dated 29/11/2023 and 10/5/2024, police seized the cultivated paddy which were lying on the paddy field after cutting down from the plant. As both sides demanded their ownership on the paddy by hook or by crook, chance of breach of peace could not be ruled out. Finally, police seized the paddy and gave to the Jimma of local disinterested people in presence of local witnesses. And what did the disinterested people do with the paddy?
That I'll have to take instruction to notice the report. And
How many times?
point of time this was kept.
Disinterested people in presence of local, then you take responsibility for giving that the paddy to the custody of the disinterested people in presence of local witnesses, as well as full concept of both the petitioners as well as defendant number 10. The said paddy is lying as Jimma till now, and presently the said disputed land is in vacate condition. No one is farming there at present. Photograph. Sir, let us finish it off. I'll fix it for orders.
Lordship,
Okay, sir.
kindly give interim, Lordship,
What
because
interim?
I cannot,
Nothing
I cannot
happened to you.
cultivate, Lordship, and I will show one case.
Yes, Baba.
It was disposed of 12th August 1996. Same similar type of criminal case has
Sir,
been.
through the writ court, you cannot get your title decided.
No, I am not praying for title,
The parties
Lordship.
go to
I am
go
the,
before the concerned
I am
court
possessing
and establish
I am
their
only-
individual right to the seized paddy.
my humble,
Right, sir?
I humble,
My lord.
Lordship, my humble prayer is only
Now you go and find out whether the
return the
paddy
paddies
that you have
and protection.
kept in the custody of those
Nothing else.
disinterested people have still kept it in that condition or not. Chanchal.
My humble prayer is, Lordship, two prayer, Lordship, return
The way you said, sir, I thought
Lordship,
it must have been seized and kept in the Malkhana or somewhere.
under
Local disinterested,
illegally, Lordship,
local disinterested person. What was the
Lordship, may I submit?
amount of paddy seized? That also is not there.
That is there.
There's there. So you first find out.
Twice.
And the second one, quantum is mentioned over here. One is 800 kg.
Yeah, one is 800 kg. The other one is
680. The second page, first one.
680. Yes. One was seized in the year 2023 and the other one 2024. One nearly 2 years and the other one Yes, more than
a little more than 1 year.
Probably that this is a civil court order. We have no
We have annexed. We have annexed pattas and
the
water
submission.
pump. Lordship, water pump receipt. 1999.
I'll just hand over one letter from the government side that will clear up the entire.
Kindly serve this.
Please do have. Wait, divest হয়ে গেছিল এটা.
Sir, I think you had earlier shown this.
Yes, look, I have. This is divested and thereafter courted order divested হয়েছে. Record correction এর জন্য already proceeding চালু হয়ে গেছে.
Probably had.
But police has police authority to seize and harass
Your
the
lordship, so desire
petitioners
to do so
lawful
immediately.
It can be done.
position if not decided, Lordship.
You had shown this to me.
I have.
While this is adjudicating matter, after without having any order, how can police interfere in my position? If I do not be a, suppose I do not be a.
But sir, you are the BLRO.
No, I am appearing for the private respondent whose land was first not acquired.
But then, sir,
Accepted,
this has to come through the state.
But that is the reason, Lord, he should have filed it, my lord. And thereafter, there is a notice given, my lord, also for hearing.
Yes, sir, I know.
I've only got the report. These are
Hearing এরও notice দিয়ে দিয়েছে সবাই.
Because I remember, sir, I think I had asked somebody to place this in the form of an
If you
BLR
directs, I can do so, my lord. Or if my lord,
Eh,
Mr. Ganguly is my lord directed, he can also, my lord, do.
because it is anyway a public document.
Lord. And subsequent, my lord, there is also a notice of hearing, my lord, pursuant for correction of the record of right.
If private respondent submitted application for record of right,
Sir, will
claiming
you file it?
themselves on our lordship,
It will be better if
but it
he
is
files
not a.
it.
Very well, my lord. Very
He
well.
files it. You give him a
তোকে আমি
copy if you
তোকে
want
একটা কপি
to.
দিয়ে দিচ্ছি আমার copy.
Sir, you file it in the form of an affidavit and you give them a copy.
Interim order lordship to protection, for protection. My humble request is the poor cultivators.
Who is doing what to you, sir?
Nothing, lordship,
Think
only
preventive.
protection.
Why?
They are attacking
It's
lordship.
an ornament.
They are attacking lordship. They have filed case and nobody can
You go.
fight my case
So
in the.
this is the
No, only protection. I need protection, lordship.
Your land is vacant. Nobody is going there. What kind of protection?
I want to cultivate, lordship.
Let
It is
me
my
read.
only
You do.
earning.
You go and cultivate. If you are prevented, you take necessary action. But that is not here.
I have also given so many
Acha,
representation
but,
for protection, but they have not protected. Police.
Now it has been divested.
Police has not protected us, lordship. While we are cultivating the land, they seized. They tried
Sir, whether you will be granted the right to cultivate or not is not the issue here.
They should. It is the.
Right.
I am on the possession, lordship. Possession itself is the right,
Advocates representing the
as per several guidelines of the Supreme Court of India,
private
lordship.
respondents and the state respondents.
Kindly, my humble submission, kindly give interim order, only one order, lordship, only protection.
Is to file a
Protection.
supplementary affidavit annexing the document of the Block Land and Land Reforms Officer, Old Malda, dated, is it 9 or 3?
Nine. Lord, it is 9th. 9th of February 2020.
9th of February 2024. On the next date of hearing. Next date be fixed on 24th of November for orders.
As your lordship. Great. Much appreciated.
Obliged.
The সোমনাথকে ওইগুলো দিয়ে দিই। The hearing notice to much appreciated.
ওই যেটা ডাকছিলাম
Lordship, the last submission as made by my learned senior friend, his one shop owner has come before the learned tribunal, said 10-15 days ago he has come with by riding a motorcycle to my shop for purchasing medicine. So Lordship, why? I'm answering Lordship kindly. Now. So with the paperwork. Lordship, kindly come to Lordship, kindly come to the evidence of PW3.
Page kota?
Page 24. 24. Lordship, here the victim was the indoor patient of the Apollo Hospital. One of the employee of the junior assistants of the medical record has produced, wherefrom Lordship found that I have this middle after 4 lines. I have brought 2 separate discharge summaries regarding treatment of patient of Joynaran Singh in our hospital for the period of 25th August 2014 to 16/9/2014, and for 1st December 2014 to 4th December 2014 respectively. These are discharge certificate summary such and such. I have brought the breakup bill along with the final bill of 9,07,067. So let's kindly see the bill. So what is the gravity of the injury? Regarding treatment of patient Joy Nursing for the treatment of 25th August 2014 to 16.
Did you get yourself treated?
Lordship.
Where did you get yourself treated?
From Apollo Hospital. Apollo Hospital, Lordship. Thereafter, Lordship, kindly see that.
Where is your disablement certificate?
Disablement certificate, Lordship, kindly turn to page
101.
Disablement
101 my disablement certificate.
Which page?
101. Sir, আমি বলি আপনিও বলেন তাতে।
Which page?
Page 101 101.
101.
Lordship, kindly see
101 disablement certificate.
103 103. 103.
103 and 104.
40%.
Yes, 40%. But Lordship, kindly see the evidence of the doctor.
What has happened?
Yes, Lordship. Lordship, the evidence is there. Lordship, kindly come to the evidence of the doctor. Lordship, kindly come to page 27.
Yes.
Yes, Lordship, kindly see I am posted such as orthopedic surgeon. On posted capacity, I have bought the certificate OPD series, and then Lordship, kindly the last paragraph. Since I treated the said patient in the year of 2015, I am not in a position to pass any comments regarding present condition of the said patient. In the year of 2015, his fracture was not united. He was incapable to run or walk smoothly. But person can ride the motorcycle, but he can run, walk, and smoothly. That evidence is there. His marriage life was affected in the year of 2015. If rod is required to be removed, the patient will have to spend lot of money. So rod is still inserted. In this case, since there is no infection, the rod will have to be removed. It will have to spend a lot of money. That part the learned tribunal did not consider.
and see the cross also.
Sir, আপনি বলুন স্যার, আপনি বলুন। And then Lordship, kindly come to the cross version, page 20th, last line.
Page?
Page 28th, last line.
28.
Lordship, 28. He was suffer from compartment syndrome, from which he was muscle neurosis, which had to be taken off, and he needed plastic surgery. It has come on their cross-examination. It's not the chief, it's the cross-examination that truth has come.
Where is trial court's, where is the tribunal's observation?
Observation, lordship, kindly page 152.
152.
Last paragraph which I placed. Therefore, the amount of compensation is calculated 1,24,369. That means the annual income. It means the monthly income 70,000 for loss of 7 months. And lordship 10,000 that medical expenses that has also been incurred, and that has been awarded by Learned Tribunal. I have no issue.
10,000. 10 lakhs.
That has been awarded by the Learned Tribunal, that the exhibit is there. And lordship, my Learned Tribunal also said the 5,50,000, that 5,50,000 I am not paying for, because of against that 5,50,000 I did not adduce an evidence. So I have no right to say this, that evidence is there. Lordship kindly consider that. But apart from that, whatever Learned Tribunal consider, I am happy with that. I have no submission on that score. And lordship, the 2 lakhs only continue on the pain and suffering, and 1 lakh for amenities of life. Ultimately come to a conclusion 14 lakhs 55,960. But the Learned Tribunal, after that lordship, the bona fide awarded, but OP insurance company will pay 50% said amount on the issue of contributory negligence. So there is no contribution of the victim in the accident. There is no evidence to that extent. A charge sheet has been filed against the offending vehicle. After that, just
Then where is that observation of contributory negligence in the judgment?
Only their submission.
Where is it, sir?
Yes, lordship. Lordship, they have submitted that
48.
and
And
48 on that score, that
Yes,
the
given
lordship
all the-
kindly come to that OP insurance took the specific defense of contributory negligence in paragraph 2 of the written objection. So observation can be hold that the victim invited contributory negligence while he was driving his father's motorcycle without any proper authorized or without following the provision of rule 3 of the motor vehicle rules. Further observation held that the driver of the vehicle number such and such is not solely responsible for the accident.
Not
Under what evidence, under what score the Learned Tribunal come to a conclusion?
Apart from the victim himself, anybody else came to depose?
Yes.
Who? Apart from the official witnesses.
Apart from the official witnesses, lordship kindly.
What did the charge sheet say?
Charge sheet said entirely against the offending vehicle.
Who are there apart from the victim?
Lordship, apart from the victim, the
No one.
shop owner,
Medical shop owner.
and one doctor. 5 witnesses there.
Charge sheet is in which page?
Charge sheet is lordship kindly turn to page. Charge sheet page 34. Lordship kindly page 39. During investigation, collected or before the evidence.
Wait, sir, wait. That observation of the tribunal, where is it? Which
The
page?
observation of Learned Tribunal, lordship, page 142. 142 to na? No, so sorry. 143. No. ভুল বললাম।
Now, you raise the issue of contributory negligence.
Yes.
48 man, 148.
130.
148 continuing. Elaborately stated, 148 man.
Yes, lordship, 148. What is that? The deceased riding his father motorcycle, not compliance the rules, and for the reason, she come to a conclusion, there is a contribution. And Lordship, kindly come to page
You
137.
mean to say apart without authorization
Yes,
and
he's a
following?
father's motorcycle. So is it required to take the authorization from his father so I can ride my father motorcycle? So on the courts come to a conclusion, this is a contribution of the victim to the accident that has to be proved. But that cannot be a ground. That is the contribution of the victim to the accident. He may be punished. He may be the fine will be placed, but he cannot be.
Motorcycle was driven by the victim.
Not driven by the victim.
He was alone.
He was along with another person.
With Meso.
With riding by
Meso, he has vanished. Motorcycle also vanished. There was seized. It was in first line of the 148. Motorcycle was not seized at all, man.
Not required.
Because of plan, they know that this is contributing negligence point will come. They have vanished that. Motorcycle has total
Charge.
Not
the
required.
police did not seize the motorcycle.
No, this most surprising.
Not required.
What
Because
surprising? Lana also was a surprise. The motorcycle was a seized. 145, 148, 147. The victim's motorcycle bearing of such and such has not been seized.
Not required at all.
140. Why?
Not required at all. I have been
partner of the accident.
Sir, bolte din, dujone
Bol.
I have been dashed by the offending vehicle. I have lodged complaint against the offending vehicle. The charge is submitted against the offending vehicle. So I have made a claim application against the offending vehicle, including insurer. So insurer has to pay the compensation. They did not adduce any evidence on my part that I have some contribution to the accident. They did not adduce any kind of evidence to prove their case. More so, the award passed by the learned tribunal, they have satisfied. They did not face any individual appeal or cross appeal in this regard. And the learned only of the observation that we have not papers. If he not seized, because of I have police found regarding inquiry that only the offending vehicle is the only the offender.
Offending vehicle is only the offender.
Yes.
And the offending vehicle is not seized.
Offending vehicle seized. My motorcycle not seized. The motorcycle, you kindly come to the first paragraph, the observation of the learned tribunal. On brief, on 25th August 2014, as such and such, or proceeding towards SP mode Tiltola bus, motorcycle, truck running recklessly, high speed, and you kindly see that. No, more one against the motorcycle, and the victim severely injured.
I will, on the other occasion also, I told you.
No, Lordship.
Sir, you will get matter.
Lordship also heard the matter. Lordship also heard the matter. Lordship, kindly come to page 152. Just kindly come to page 152. The issue raised by my learned friend today, but they did not raise the before on that occasion. My humble submission, the learned tribunal ought to have considered the.
Monday, my lord, I have some difficulty. Take it on to Tuesday, my lord.
Tuesday, I will do it today itself.
101.
Lordship, kindly see, my humble submission is that the learned tribunal ought to apply the multiplier and the income.
His matters totally deleted from the list.
One disable certificate, madam. It was issued for 5 years. It was issued on 19/1/2017, and it was expired on 2022.
You please keep quiet.
Judgment of
contribution negligence is there, madam. I am just only saying, madam. This is my.
No,
it's not there.
It's not there.
But if suppose he was the pillion rider, what would have you done?
He has a pillion rider also. The Mr. Musa, he's gone. Motorcycle gone. Motorcycle is cleverly, man, it is suppressed, man.
How?
It should be seized.
How?
They have not given the police a motorcycle.
You have the disputing the fact. We have evidence.
Need to raise this issue
before the tribunal.
Ashif,
document of
Oh,
medical examiner
please.
আমাকে বলতে দাও তো এবার তুই অনেক বলছিস
তোমার জাজমেন্টটা
So the
No, Lordship, that not consider, Lordship, 40% reservement certificate not considered by the learned tribunal, Lordship. Lordship, kindly see the judgment, not at all consider the 40% reservement. The certificate not considered. I have received that amount after deducting only that the.
See, I can't, I mean, give you any.
So, Lordship, kindly that part, kindly dictate later on.
103